This is You and the Law on AM 650. Now back to the show.
David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver in studio on this edition of You and the Law. We're talking wills and we're talking executors and administrators, and we're at a point in the program where in our last segment the word caveat came up, which essentially is a document that a person involved in a will or possibly involved in a will can file with the probate court, essentially stopping the forward progress of a will. Is that an okay definition, David? Am I kind of with you on what a caveat does?
Yeah, you're very close. I would have just said it stops the application for probate. Doesn't stop the will necessarily, but stops the court from giving the grant of probate.
So then what happens, Ian, when that process, which is fairly automatic, albeit somewhat intricate, when that process is stopped, what happens then?
So if you're the appointed executor under the will, and you believe that the will is valid, that the caveat is improper in some fashion, there's various mechanisms you can try to employ to get rid of the caveat. One is to send a notice to caveator. So this is another document where you say, please remove this caveat, and unless you do so, unless you file a notice of interest with respect to the estate within 7 days, the caveat will be struck.
Okay, all right.
The problem with that is the caveat, when you file a caveat, it's only good for 6 months, and then it lapses. If you serve the caveator with a notice to caveator, and they do file a notice of interest, that essentially extends the caveat
for another 6 months?
Indefinitely.
Oh, really? Oh, just leaves the door open.
And now it will have to definitely be dealt with on a more formal level.
Oh, okay.
And that might involve bringing a court action to prove that will in solemn form. In other words, now you're in front of a judge with evidence, providing the judge with the comfort that this last will is valid and that it should be probated.
Does this caveat process, David, happen often? People, before really anything gets done, they're already disputing. They're already in there swinging with both fists.
Oh, it happens often, and if the dispute is going to be about the will, whether it is the last will, a valid will, and so on, then a caveat's going to be, you're going to see a caveat filed if a person is getting legal advice, because you don't want to let the executor carry on as if that will is unchallenged.
Yeah, because you don't believe it's the right document in the first place. Is it usually because there's a second will at play that maybe favors you more than the other one? Is that generally, Ian, the reason rather that people would go through this process in the first place?
Well, I was going to. That's an interesting question. And I apologize, Ian, for jumping in there. You have to ask the question: if we knock this will out, what happens? Mm-hmm. And that requires maybe looking at another will or looking at an intestacy. Sometimes we counsel people not to attack a will and to come at it as a Wills Variation Act claim.
Right.
So even though you might have a basis for attacking it, why don't you let that will remain, but attack it as to whether it's adequate and fair?
Ah, okay. So there are strategies here that would be more effective in some cases than in others. Now, the other word that is still out there dangling for a definition is citation. Ian, what is that all about?
Well, a citation is basically a summons, and there's different types of citations that can be filed in the probate registry. One of them is a citation that is directed at the named executor under a will to accept or refuse probate. In other words, to get on with it.
Oh, okay.
And normally that's issued several months to a year or more after the will maker has died, and the executor is not proceeding with a probate application for some reason.
Oh, they haven't even got that part.
And let me give you a good example of where we see that in our practice is sometimes the named executor may be living in the deceased's, the will maker's house, for example.
Okay, yeah.
Lived there as an adult child or a spouse
or
forever and ever,
or
forever and ever. Mm-hmm. Kind of likes the setup. Doesn't really want to get on with probate because they don't want to call in that asset, sell it, distribute it
and
in accordance with the will, and lose their home.
Right.
So sometimes they have to be pushed a little bit. So,
They start to drag their heels a little.
Right.
And
So-
of course, everybody else, all the other players on the field are going, hello, we're here too.
right. And what they're doing by issuing the citation is they're saying, get on with it. And if you don't get on with it within 14 days, you're going to have to come to court and explain why you're not getting on with it. And we may show up at the same time and say, you should now substitute one of us to do the job.
Oh, so David, this is serious stuff. When someone is given the citation to keep the ball rolling here, this is serious. This is not to be taken lightly.
It forces the issue. People then they can't sit on their hands anymore. They have to do things.
Okay, now at Hobbs Giroday, you don't do wills, but you do advise executors and administrators. Is this a problem in which you find yourself advising executors on a fairly frequent basis? Do people come to you going, well, I'm not in any hurry. I'm kind of peachy here where things are. There appears to be no problem with the rest of the people who may or may not be named in the will, so I'm not in any hurry. Why should they be?
Well, part of the problem of not getting on with administration of an estate is you may be creating a liability for yourself. Let's say the stock market was doing great when Mom died, and you sit on your hands for 6 months or a year and you're slow, and all of a sudden the stock market's not doing so great and the value of the portfolio has gone down, and eventually at some point it could become an issue that you've been negligent in the administration of the estate.
Aha.
And that would apply to any asset that might appreciate or depreciate. So there's a danger in sitting on assets because their values can change, or assets can become harmed by fire or theft or other incidents. So there's personal liability for unbusinesslike administration of estates.
Ian, I asked this question earlier and then just let it ride. But back to the whole matter of assets that David was just discussing, especially if you've got stocks or other investments, vehicles like that, and you have outlined in your will that you want the stock rather than the cash value of the stock handed to your dependents as you've identified them in your will. And the stock market has just gone for a tumble. Suddenly that is not such a great thing to be passing along, and yet I guess my question is, does the executor have the right to step in and go, well, the market's going south here. We should sell these stocks now while there's still some value so there can still be some money to be distributed, yet Mr. Smith specifically requested stock to be transferred to his descendants. Is the executor capable of doing that?
In other words, calling in the stock.
Yeah, and transferring it to cash.
Not if the will directs
Interesting.
him or her to do.
Then you do what you were asked to do.
That's their job, is to follow the directions under the will.
Interesting.
Now, that's not completely etched in stone in the sense that if there's some issue with the directions, it's always available to an executor to go to court and seek the court's blessings to do something slightly different than what the will calls for.
Okay. So there are possibilities, at least. It's not all black and white.
It's not black and white, but generally speaking, your directions come from the will, and
Sure.
and they are what they are.
That's why you were appointed executor. So if you've been listening to the program today and maybe have been asked to be an executor, and you're going, oh my goodness, what have I just got myself into? Perhaps, just perhaps, you should have a chat with my guests, David Hobbs and Ian Giroday. They're downtown in Vancouver on Howe Street, and they're on the web at hobbsgiroday.com, and they would be very happy to take your call and have a chat. David Hobbs, Ian Giroday, thanks, guys. Wonderful to see you again, and we'll look forward to another conversation soon.
Thanks, Sterling.
Thanks, Sterling.
See you next time on You and the Law.